Despite millions of vehicles on the road, most people don't understand their privacy rights in their vehicle. Some people think that just because they get pulled over, the police can always search their car, while others think that they never can search their car, especially individuals who sleep in their vehicle or if they have a motorhome. I think the truth is somewhere in between. Now, I welcome you to the 5th part in my 10-part series where I discuss 10 of the most important Supreme Court decisions and the myths surrounding them. Now, if you've been paying attention, we've now discussed the right to counsel, right to remain silent. We've talked about stop and frisk. But the reality here is that most of us will never be stopped by the police on the street on foot. I think most of our encounters these days are when the police stops us in our vehicles. So today, I'm going to introduce you to the automobile exception. If you're interested in all the exceptions as they relate to the automobiles under the 4th Amendment, I urge you to find and watch my series called Vehicular Searches Without a Warrant, where I discuss all the exceptions to the warrant requirement under the 4th Amendment as it relates to automobiles. Today, in this series, I'm just introducing you to the concept. So today, in this 5th part, we're talking about Carroll versus United States and the automobile exception. Thanks again for watching my channel. If you're new to the Law Stash channel, hit that subscribe button. If you're listening to the podcast version of this recording on Audible or Spotify, please give my podcast a 5-star rating. And if you want to support this channel, consider going to lawstash.com/merch or shop.lawstash.com and check out these Do Not Arrest This Person t-shirts, hats, stickers, pins, and other items. And if you're watching this series, type in 10 cases to receive 10% off. Thanks for watching.
Quick message from Law Stash. Are you charged with a crime? Or do you want to know your rights if stopped by police? Watch California attorney Anton Vieltsin discuss legal cases from the Supreme Court, Ninth Circuit, and California state courts on the Law Stash YouTube page. Anton has handled hundreds of federal and state criminal cases, has an in-depth knowledge of the law, and has the best mustache ever. Subscribe to the Law Stash YouTube page. That's LAWSTACHE.
In the early 1920s, during Prohibition, Mr. Carroll was suspected of driving alcohol across state lines in violation of federal law. A few months earlier, federal agents tried to buy alcohol from Mr. Carroll, but the deal fell through. Now he was driving across state lines on a known smuggling route, and the officers pulled him over. Without a warrant and without consent, they pulled the tarp and they found alcohol in the vehicle. He, of course, was charged, but he claimed that the officers violated his 4th Amendment rights when they searched his vehicle without a warrant. Now, the case goes all the way to the Supreme Court with a question whether the 4th Amendment protects you in your automobile. Again, the 4th Amendment protects against unreasonable searches and seizures, and generally speaking, officers need to have a warrant before they conduct a search. But here, the officers did not have a warrant. And usually we say that warrantless searches are per se unreasonable. The Supreme Court disagrees with Mr. Carroll. In a 6-2 decision, they say that officers can in fact search a vehicle without a warrant as long as they have probable cause to believe that the vehicle contains contraband. So again, no warrant is needed, but only probable cause. That is your Carroll decision and the introduction to the automobile exception. Now, a century later, we still have this law. It is still a good case, and officers can still search vehicles without a warrant as long as they have probable cause. But what was the reasoning? The reasoning a century ago was that it was too difficult for the officers to obtain a warrant because of the vehicle's mobility. A person can simply drive off. But now, here of course, essentially later, officers can even obtain warrants through telephones. Telephonic warrants exist, but this case is still good law. So remember, as long as officers have probable cause to believe that the vehicle contains contraband, they can search the vehicle without a warrant. So now let's move on to the 10 biggest myths surrounding this case. Myth number 1, police can search any car they pull over. Again, they do need to have probable cause before they search the vehicle. Myth number 2, Carroll gave police unlimited authority to search vehicles. Nope, this is not a blanket rule. This is an exception. So we still start off with the point that warrantless searches are per se unreasonable. This is just an exception, and it only works with automobiles. Myth number 3, a traffic stop automatically allows a full search of your car. That is not true. Because the officers need to have probable cause, some stops will never lead to a search. For example, if you get pulled over for speeding or for broken taillight, there is no probable cause to believe that evidence of the crime would be found inside the vehicle. Of course not. What kind of evidence would they be searching inside the vehicle for speeding? That is, nothing would be found inside the vehicle. So there is no probable cause. So only for a certain type of stops can the officers claim automobile exception. But remember, all of these exceptions do work together. In my other series called Vehicular Searches Without a Warrant, I describe all the exceptions to the warrant requirement as it pertains to automobiles. And for example, the plain view doctrine, where the officers, by standing outside the vehicle, can see something incriminating inside, because of that exception, the officers will then be able to use the automobile exception to conduct a full search of the vehicle if they initially see something illegal through the window. Myth number 4, the Carroll doctrine means cars have no Fourth Amendment protections. Again, because of mobility, the vehicles have less privacy. You have less privacy in your vehicle, but it doesn't mean that the whole Fourth Amendment is eliminated. If you lock some of the stuff inside the glove compartment or you hide it in your trunk, of course, now the officers don't have the plain view doctrine. They can't see anything inside your trunk. And so, even though Carroll doctrine expands the governmental authority to conduct searches without a warrant, again, it is not a blanket rule. Myth number 5, officers can search a car without a warrant just because the driver consents. Again, look at my other series dealing with vehicular searches. Consent is a separate exception to the automobile exception. I remind you, never consent to searches. But if you do, the only question later is going to be whether that consent was voluntary. Again, consent has nothing to do with automobile exception. Myth number 6, if police find evidence during an illegal search, it can always be used. Well, exclusionary rule still applies even to these cases. So the court will look whether there was probable cause, and if there wasn't, that evidence can still be excluded. Myth number 7, Carroll lets police search any part of a car, even without probable cause. Automobile exception still has the scope component. The officers still have to later tell the court why they searched a particular part of the vehicle for evidence. So if they're looking for drugs, drugs can be hidden in the trunk, inside the vehicle, and so on. But if they're searching for something bigger that can't fit into the trunk or the glove compartment, perhaps they can't go in there. Myth number 8, Carroll applies only to liquor cases from Prohibition era. That's not true. As I said, automobile exception has now been good law for nearly a century. So we're talking about almost a full 100 years. This case is from 1925. it is still being used today for more than just liquor. Officers routinely find narcotics, firearms, and other contraband inside the vehicles by using the automobile exception. Myth number 9. Carroll allows random spot check searches at police discretion. Suspicionless searches are still unconstitutional. The automobile exception is just that. It's an exception. And it works separate from any sort of checkpoint type of searches. What do I mean by checkpoints? Well, we have immigration checkpoints, we have DUI checkpoints, drug checkpoints. In fact, earlier this year, I posted a video about drug checkpoints, which are deemed unconstitutional under the Fourth Amendment. I will also tell you that later on, the officers tried to get around the fact that they're unconstitutional by putting what's called ruse checkpoints that would say that there's a checkpoint coming up ahead on the highway when there really wasn't one. And they would look for individuals who would take the exit and then pull them over. The court said that is also illegal and the violation of the Fourth Amendment. Officers need to have a reasonable suspicion that a crime is being committed before pulling somebody over in their vehicle. But again, checkpoint searches are separate from the automobile exception. And finally, myth number 10. Once probable cause exists, police can always search a car without restriction. Well, that is not completely true. Of course, there's still checks and balances, and the court will see whether probable cause actually existed. I will tell you that your lawyer will probably try to argue to the court the probable cause did not exist, and thus the officers violated your Fourth Amendment rights. So this was an introduction to the automobile exception or the Carroll Doctrine. I urge you now to go and find my series dealing with all the exceptions. That series is called Vehicular Searches Without a Warrant. I will link it in the description below. I hope you're enjoying this particular series. If you're new to Lost Ash channel, hit that subscribe button. If you're listening to the podcast version of this recording on Audible or Spotify, please give my podcast a 5-star rating. And finally, if you want to support this channel, consider going to lostash.com/merch or shop.lostash.com and check out these Do Not Arrest This Person t-shirts, hats, stickers, pins, and other items. And because you're watching this series, if you type in 10 cases, you'll receive 10% off. Thanks for watching, and I will see you in the 6th part of this series. And if you've missed the previous videos, of course you can watch them in any order. So again, we've talked about your right to counsel, right for an attorney, your right to remain silent, stop and frisk. Watch those videos, and I will see you in part 6. Thanks for watching.